Let's say your foreign invested company in Vietnam needs additional funding. Instead of applying for a bank loan or bringing in new investors, you decide to borrow directly from an existing foreign shareholder. At first glance, it feels simple. The lender is already part of the company, there's trust on both sides, and the money can move quickly. But here's the part many businesses overlook. Under Vietnamese regulations, borrowing from a foreign shareholder is generally treated as a foreign loan, just like borrowing from any overseas lender. And if that loan isn't structured or registered properly, it can lead to regulatory issues, blocked repayments, or tax complications down the line. In this video, we'll walk through the legal requirements for borrowing from foreign shareholders in Vietnam, along with practical tips to help you do it the right way from the start. Let's clear up a common misunderstanding. The fact that your lender is a shareholder, even a major one, does not exempt the loan from foreign loan regulations. In Vietnam, any loan received from outside the country, including loans from foreign shareholders, is generally classified as a foreign loan. That means the same core rules apply. Loan agreements must be properly documented, long-term loans typically need to be registered, and disbursements and repayments must go through designated loan accounts. Treating shareholder loans as purely internal transactions is one of the most common sources of compliance risk we see. So what does the law actually require when borrowing from a foreign shareholder? At a minimum, you'll need a written loan agreement signed by both parties, with clear terms on interest, repayment, and maturity. You'll also need a designated foreign loan account in Vietnam to handle disbursements and repayments. If the loan is long-term, or if it may later be converted into capital, registration with the State Bank of Vietnam is typically required. Even short-term loans need close monitoring. If a short-term shareholder loan is extended or remains outstanding beyond 12 months, it will generally be treated as a long-term loan and become subject to registration. Two main authorities are usually involved in shareholder loan compliance. The State Bank of Vietnam oversees foreign loan registration and foreign exchange compliance. At the same time, the Department of Finance plays a role when loans affect capital structure, investment certificates, or ownership ratios. This means companies often need to coordinate across both regulatory regimes, especially if loan terms change or if a loan is later converted into equity. There are a few practical steps that can significantly reduce compliance risk. Using a formal loan agreement is essential, even when the lender sits on your board. Avoid backdated disbursements, as they frequently raise red flags during audits. Track the 12-month timeline carefully, particularly for short-term loans. Always use the correct designated loan account for fund transfers. And if conversion to equity is a possibility, plan for it from the beginning. These steps may seem procedural, but they make a real difference when it comes to regulatory review and enforcement. In practice, we often see the same mistakes repeated. Some companies treat shareholder loans as informal arrangements and skip registration altogether. Others disburse funds before the loan agreement is properly signed. In some cases, companies use ordinary operating accounts instead of designated loan accounts. And sometimes, changes to repayment terms are made without updating the registration. Even when loan amounts are relatively small, these mistakes can carry serious legal and financial consequences. At LTS Law Firm, we help foreign invested companies structure shareholder loans in a way that is both practical and fully compliant. Our team assists with drafting and reviewing loan agreements, assessing whether registration is required, setting up compliant disbursement channels, preparing and filing documentation with the authorities, and planning for future restructuring or conversion where needed. Whether this is your first shareholder loan or part of a broader financing strategy, we focus on getting the structure right from day one. Borrowing from a foreign shareholder can be an effective way to support your company's growth, without bringing in new investors or taking on bank debt. But it's still a regulated foreign loan, even if the lender feels like one of your own. If you're planning a shareholder loan, or already have one in place, contact LTS Law Firm to ensure it's structured correctly, registered where required, and flexible enough for the future. Visit www.lts.com.vn or reach out to our legal team for a consultation. A well-structured shareholder loan can be a powerful tool, as long as it's done the right way.